when phones just ring, emails ignored, service charge high, can't be afforded. You're stuck down low, heat turned off, doors won't lock.
Hello, welcome to episode 3 of This is the GSA Way, a podcast set up by a GreenSquareAccord resident for other GreenSquareAccord residents. Following on from the success of our website, in which we have united the voice of many disgruntled residents, GreenSquareAccord continue in their legal action to get this shut down and taken down. And August the 6th, last Tuesday, was our latest court date. In this episode, I'm going to give you a bit of the background so you can understand the context in which they are pursuing this legal action, the threat of imprisonment, which is very realistic and is still looming over, even though we've been going through this for a year now, me and my wife, friends and family. We'll give you some of the background, an idea what to expect, and we'll again put some solutions on the table, because there has to be another way other than legal action, which is costing GreenSquareAccord and in turn us residents. Anyway, this is episode 3 of the GSA podcast, Imprisoning the Voice of the Customer. Okay, to give you an idea of the background, I started raising complaints in 2017, 2016, something like that. And these complaints were fairly substantial, and I'm not going to drone on about them now. If you want a full list, you can find it over here on the GreenSquareAccord resident website. There's all sorts of posts in there which highlight all the ongoing effort. Now, before I set up this website, I had compiled about a 70-page document that was full of evidence of email chains, of breakdowns in communication, of failures, of video evidence, photo evidence. It was all there, and I threatened to share this because I was being ignored by GreenSquareAccord. And this was when they were GreenSquare, so this is pre the merger. They were just GreenSquare and hadn't yet merged with Accord. So obviously they wanted to keep a lid on things. Now, I'd been told by certain GreenSquare employees that they hated bad publicity. That was the last thing they wanted. And this turned out to be true, because as soon as I said, well, look, if I'm not going to get anywhere with any of you, I'm going to share this document, I was granted a meeting with Ruth Cook and her then right-hand woman, Rachel Crownshaw. And the meeting was cordial enough. I think I've said this in the past. It was a cordial meeting. They agreed to fix these windows that wouldn't shut and open. And we're going to do that, and then we're going to take some of the money out of the sinking fund, but they were also going to upfront about 50% of it, which seemed agreeable, because it's never been about the money. It's about getting our homes safe and secure, and not being able to do. Some residents couldn't open windows while other residents couldn't shut windows. That's a security risk. It's also a health risk. You know, you have to be able to open and close windows. That's why we have windows that open and close. It's not too much to ask for that the homes that we live in have windows that you can open and close. And Ruth Cook and Rachel Crownshaw seem to agree with me. So they offered some money for that. And there were some other conversations that we had around some of the other issues. And what's more, it's the only time I've actually heard Ruth Cook apologise. And I thought the meeting went well. I thought, okay, look, we've gotten through to someone. We've gotten above the customer service desk. We've gotten past the middle management who just sort of run around. We've got past the senior management who seem to want to keep everything down below. And we finally got engagement for the CEO and Rachel Crownshaw, who was then head of operations, I believe. Anyway, that all went swimmingly. And then the merger happened. And then it was back to service as normal. Appalling service. The lifts weren't being fixed, the leaks weren't being addressed. Yeah, it was an absolute nightmare, and we still waited many months before we got the windows fixed. So I joined them. Part of the conversation that we had, I joined them to join their customer panel, and that was just a waste of time. It was a tick box exercise. People arguing over the meaning of words which were exactly the same as to what they should put into their credo. It was really ridiculous lowbrow stuff and a waste of my time and effort. And then leaks continued. We had smoke alarms going off. So one evening, I say evening, it was early morning, about 2-3 o'clock in the morning. Having reported this time and time again, they still didn't fix the smoke alarm. So again, we're all woken up by a fire alarm that's going off because of a defected smoke alarm. And this caused, we have vents in the window vents in the ceiling of the main corridors, which open up, and it was chucking down rain. So it was pouring rain upon the landing, and the smoke vent wouldn't shut it. There's a button that wouldn't shut it, and we couldn't silence the alarm. So I was up until sort of 5, 6 o'clock in the morning going through all of this, at which point I put an email together, and again I put everyone a copy, including board members. You can find out more about that here. So we went through all of that, and of course as soon as I did that, Rachel Crownshaw, who I should imagine was pretty much the architect of the communication plan, although other housing providers have said to me it's something we've got but we never use unless it's abuse, and I'm never abusive to them. I just call them out for what they are, which is a waste of time primarily, and fail to do the bare minimum of their requirement. So she initiated this contact management plans, which said, well, you can't email any of us, you can only email the customer service desk. And I went, oh, you know what, if you're going to do that, I'll just put it all online, which is what I did, which is how the residents website, GreenSquareAccord residents website, was founded. And as soon as this has happened, and I say as soon as happens, they had to wait for their logo to be copyrighted because of the merger. They'd recently done their new logo and it wasn't yet in copyright. I could have contested it and said they had their copyright, but I didn't want to do that because they'd already spent the money getting all their vans labelled and all their headings, and I thought, no, I won't do that. However, GreenSquareAccord decided that I was misusing their logo because they often use their logo. They didn't understand fair use. They did say to me that I'd skimmed a lot of photos off their website of properties. And they said, well, you don't own the copyright to them. And I thought, oh, you know what? I don't own the copyright to them. No, that's right. So I will take those photos down, but I'm going to continue seeing using your logo because it's fair use. To which their customer service director, Julianne Brinton, said, well, then we're going to sue you. We'll take you to court. To which I said, well, okay, supercharges what I'm doing, and what is it that you don't like that I'm doing? So that quickly, I did get a letter from their legal team at the time, their lawyers. You can read that here. I'll put a redacted version up so you can see that. And we were off and running. It disappeared, but they didn't do anything about it. They realised, they probably advised not to. And it continued. Now, the traffic slowly built, so it wasn't a problem to them at the start, because we didn't have that traffic. But the social media sites, Facebook, Twitter as it was then, LinkedIn, obviously these things take time to build, but slowly and surely it did, especially my LinkedIn profile. And then we started to get more attention and more traction, which then became a problem for GreenSquareAccord. So that was what led us through to the first court case, the first legal action that we had. And we'll get into that now. Okay, now I think the first thing that you have to understand, this was never supposed to go to court. This was just to threaten, to intimidate, and to get me to close everything down because I was afraid of going to court. And there's lots of things that lead to belief, that sort of lend weight to that argument. And the first thing was their letter, their first letter that I received. Now, this came, as I say, right on the back of the Housing Ombudsman. And the first thing it stresses, look, you'll be subject to costs. It's costs many thousands of pounds. So it was never supposed to go to court. But what they were in fact asking via this letter was that I took down the websites, took down all the social media posts, all the social media accounts, took down all of those, got rid of my contact at GreenSquareAccord residence email address. And after I'd taken them all down, I wouldn't set up any new ones. That would remain after. I wouldn't be able to do that. I wasn't allowed to use their logo, even though we've already established that was fair use. Not allowed to contact or tag anyone on their social media posts. Now, I didn't contact anyone on their social media posts unless they specifically put that within their social media links. So, for example, Ruth Cook is CEO of GreenSquareAccord and has a Twitter account. And people are entitled and allowed to contact her through that. It's a valid form of communication. She is, as she boasts, allowed to block and ignore. She can do that. That's up to her. Steve Hayes, their communication director. Actually, Steve Hayes, he's got GSA in there. So he was really ready to use that. It was going to be his big thing, his big platform. Well, if it's going to be, good luck to you. But you can also be contacted on there and people can respond to your posts on there. Anyway, I wasn't supposed to do that. Emails, again, would still be ignored. So the contact management plan, which was their own construct, which I'd stopped using at this point. I said, well, no. By the time we got to this point, I was like, they'd already said, well, you're not a resident. Well, if I'm not a resident, how can you expect me to adhere to a contact management plan? I'll email whoever I like. So I'd stopped using that and then continued to email board members because I think it's relevant that they know. Because I think half the time, Ruth Cook is either out of the picture or keeps the board out of the picture. By putting them on email, they can't deny it later on. So if, God forbid, something awful happens, there is a loss of life, which unfortunately there is inevitably going to be with this failure of service to keep homes safe, warm and dry. We all know it's a matter of time. It is a ticking time bomb. And what will happen is Ruth Cook must have that deniability, as must her board. We didn't know about this. They'll find a scapegoat lower down. So it was important that I wasn't allowed to email them all. And I responded to this. Now, much of this can take part in letters that I can show you because I don't want to put words in their mouth and I don't want to say things I didn't say. So let's do this in a sort of back and forth of letters.
Extracts from my first response to GreenSquareAccord's legal threat. I trust this letter finds you well. I've reviewed your letter dated 11th of August 2023, which outlines the matters raised by GreenSquareAccord and your client's dissatisfaction with my online activities. While I understand your client's perspective and concerns, I must respectfully assert that I am not in agreement with the course of action you are proposing. Firstly, I would like to highlight that the homepage of the residence support website I manage, www.greensquareaccordresidence.co.uk, explicitly states that I am not affiliated with GreenSquareAccord in any way. My intention has always been to provide a platform for residents to share their experiences and concerns, rather than to mislead or misrepresent any affiliations. Furthermore, I must bring to your attention that my engagement with GreenSquareAccord and its employees on social media and through various communication channels predates the recent events that you mentioned in your letter. It is important to acknowledge that my actions have been driven by genuine concerns and a commitment to fostering an open dialogue within the community. The timing of your letter coincides with the Housing Ombudsman awarding damages to me, having upheld numerous complaints. As such, this appears indicative of the combative attitude that your client has displayed towards me since circa 2019. Given the context of my interactions with GreenSquareAccord and the transparency I have maintained throughout, I respectfully decline your request to cease my activities and comply with your outlined instructions. I firmly believe that the actions I have taken are well within my rights as an individual and in accordance with the principles of freedom of expression. They also echo the public rhetoric of your client in their own online and published material, where they often convey an attitude of working with residents to improve their service provision. Their response to the issues raised and their decision to employ you to pursue legal action seems to undermine this. While I understand your client's desire to address their concerns, I believe that open communication and engagement are vital components of a healthy community. I would like to reiterate my willingness to continue these conversations and work towards a resolution that is fair and mutually beneficial for all parties involved. I wish to draw your attention to my numerous attempts to establish communication with GreenSquareAccord. I extended invitations for a collaborative discussion with the intention of exploring more positive avenues for our mutual progress. I have also sought mediation from our local MP, councillor, and other professionals within the sector. Regrettably, these invitations have consistently been disregarded. Additionally, I offered to transfer the rights to the aforementioned websites, yet this proposition has also been ignored. I kindly request that you reconsider your approach to this matter and take into account the broader context of my actions. I remain committed to maintaining a respectful and constructive dialogue moving forward. I assume GreenSquareAccord and Redacted Legal Team are content for me to share the contents of your letter, as it again highlights the contrast between GreenSquareAccord's carefully managed image and their actual actions. If I have not received a written response from you by 18th August 2023, I will assume that you are in agreement for me to share your letter and my response as I continue seeking support from others within the sector. Thank you for your understanding and consideration. Sincerely, Ben Jenkins. My response was reasonable, logical, and made in good faith, with the expectation of a prompt reply. When I didn't receive one, I wrote again. In hindsight, given GreenSquareAccord's well-known tendency to disregard reason and logic, I should have known better. I trust this message finds you well. It has been over a month since your initial correspondence on behalf of GreenSquareAccord, dated 11th August 2023. In your letter, you raised concerns and potential legal actions, yet there has been no follow-up since my written response on 14th August 2023. Furthermore, despite my numerous attempts to engage, your client has continued to avoid mediation and constructive dialogue. In light of this, I am writing today to seek an update on your intended legal action and to present a counteroffer. I must express my concern that GreenSquareAccord appears unwilling to meet with me in line with the Housing Ombudsman's request. The approach taken by your client, which includes denying my resident status, while simultaneously requesting my agreement to a contact management plan and making other demands, raises questions about their approach to customer relations. Rather than perpetuating a confrontational dynamic, I strongly encourage your client to engage in a more collaborative and constructive manner to resolve our issues. It is worth noting that the Housing Ombudsman has upheld my complaints on 2 separate occasions, resulting in compensation for myself and my neighbours. While this is a positive step, it does not negate the challenges and obstacles we faced in reaching this resolution. It is evident that many residents still face unaddressed issues and lack support and guidance. This is the primary reason behind the creation of my website and associated social media accounts, which serve as platforms to shed light on concerns that GreenSquareAccord may be hesitant to address. I firmly believe that residents must have a voice and a means to raise issues when the customer service route proves inadequate. With your client's past failings now a matter of public record, and with several outstanding issues that require attention or external intervention, I propose a meeting between myself and Ruth Cook, along with members of her team. During this meeting, we can discuss and agree upon the following points. Apologies from both parties. While my actions have been reactive to the behaviours displayed by your client, I acknowledge that there may have been instances where my actions caused distress. It was never my intention to name and shame, but rather to highlight shortcomings within GreenSquareAccord's team. Given the increase in wages, at least 9% due to inflation, it is crucial for GSA to address employees not adhering to the GSA Way. Address outstanding issues. Both parties need to openly discuss the numerous outstanding issues that have not been raised externally. This will allow us to agree on the best course of action, and your client can provide me with a designated point of contact for future issues. This would also involve the removal of any contact management plans, as they are counterintuitive and unenforceable while GreenSquareAccord denies my resident status. Website, chart email, social media accounts. I understand your client's desire to remove these channels for residents to report issues, but it is essential to recognize the positive impact these platforms have had. Many issues have been raised and resolved thanks to my efforts in bringing them to your client's attention online. These platforms have provided residents with an alternative means of communication when traditional channels have failed. The time and financial resources I have invested in raising and resolving these issues should also be considered. Housing champions. Having customers who can reduce customer service inquiries while providing detailed and consistent stock condition surveys is a positive step. As GreenSquareAccord lacks the technology and expertise for stock intelligence, my housing sector website and third-party support can offer valuable assistance. Collaboration piece. Both parties should collaborate on a public statement that highlights the lessons learned from our interactions, our commitment to working together constructively, and the broader sector's takeaways from our collaboration. During this time, GreenSquareAccord did their utmost to avoid meeting with me, despite a directive from the Housing Ombudsman.
Hi, Neem. Please accept this as confirmation in writing that I am happy and would like to meet with you in your capacity as leaseholder of your home. As there is currently a contact management plan in place which restricts Ben's contact with anyone from GSA due to his behaviour, as set out in the contact management plan, any meeting which takes place cannot include Ben, whether the meeting is with me or another colleague from GSA. We have made the Housing Ombudsman aware of our position on this. Let me know if you are happy for me to make arrangements on this basis, and I can look at the possibility of meeting with you on either 19 or 26 July or other possible dates, as these are drawing quite close now. Kind regards, Julianne.
Dear Mrs. Jenkins, thank you for your email. and I'm sorry that we haven't yet been able to arrange a date for you to meet with either Julianne or one of her colleagues. I'm sorry also that your previous experience of our services hasn't been as either you or I would wish. I also note with concern the reference in your email to Julianne displaying behaviours which have led to you being ignored, insulted, bullied, laughed at, and lied to. This is absolutely not the standard of service which you should expect from us, and if you would like to provide me with any examples of this behaviour, I can certainly arrange for your concerns to be investigated. I'm afraid, though, that Julianne has advised you correctly regarding the proposed meeting. We have had to put in place a contact management plan, given your husband's unacceptable behaviour towards our colleagues, and therefore are unable to accept him acting on your behalf. We have written to Mr. Jenkins on a number of occasions, clearly setting out the aspects of his behaviour which we consider to be unacceptable, and asking him to cease this behaviour, given the impact it is having on the well-being of our staff. Unfortunately, he has refused to do so and has continued, and indeed escalated, his behaviour. We are therefore unable to consider any change to the contact management plan. As Julianne has previously stated, we are keen to meet with you to rebuild our relationship with you as our leaseholder, and this offer remains open to you. Julianne or a member of her team will be very happy to meet with you at a time of your choosing. Should you wish to, you are also very welcome to be accompanied at this meeting, or to nominate another advocate to act on your behalf for all matters relating to your lease. Given the terms of the contact management plan, I am afraid that we are unable to agree to any meeting at which Mr. Jenkins will be in attendance. Best wishes, Ruth.
Despite the contact management plan being their own creation and their inability to provide any evidence, such as call recordings, emails, or examples of threats or harassment, Julianne Britton and Ruth Cook continued to use it as a reason to avoid meeting. However, they eventually decided to bend the rules of their own plan and agreed to meet with me, but only under conditions they knew we would not accept.
Ref. Housing Ombudsman Service Decision. Dear Mr. and Mrs. Jenkins, we write further to the Housing Ombudsman Service Decision of 8th of August 2023. In accordance with paragraph 168B of the decision, we are writing to offer you both the opportunity to meet with a representative of GreenSquareAccord to discuss rebuilding the landlord-tenant relationship between ourselves and Mrs. Jenkins. Please note that this letter and the offer of a meeting do not in any way supersede the contact management plan in place for Mr. Jenkins, which will remain in force unless and until we tell you that we are prepared to vary it. In addition, given the behaviour which led to the introduction of the contact management plan, we will require undertakings as to acceptable behaviour from Mr. Jenkins before the meeting can proceed. Please see attached. The meeting will take place via Microsoft Teams, and we can offer availability WC 25th of September and WC 2nd October. Please respond via email to info@greensquareaccord.co.uk to confirm whether you wish to take up the offer of a meeting and to confirm the undertaking re-acceptable behaviour from Mr. Jenkins. When responding, please let us have details of your availability, WC 25th of September and WC 2nd October, so that a precise time and date can be arranged. Yours sincerely, GreenSquareAccord, Enc. Undertakings as to acceptable behaviour. Undertaking as to acceptable behaviour. Before any meeting will be arranged, we require Mr. Jenkins to confirm that he will not use offensive, abusive, insulting, aggressive or intimidating language towards any GreenSquareAccord representative at any time during or after the meeting. Record, film, screenshot or otherwise capture the meeting or the attendance of any GreenSquareAccord representative. Should this undertaking not be complied with, we will unfortunately be forced to terminate the meeting with immediate effect.
With the threat of legal action still looming and GreenSquareAccord, along with Julianne Britton and Ruth Cook, continuing to make the same unfounded claims about my behaviour, my wife and I decided to respond to GreenSquareAccord's lawyers. I trust this message finds you in good health. I am again reaching out to you in your capacity as GreenSquareAccord's legal representative. I wish to acknowledge the receipt of a letter from GreenSquareAccord dated 19th of September 2023. In the attached letter, GreenSquareAccord references the Housing Ombudsman Service decision and extends an invitation to discuss the landlord-tenant relationship involving both Mrs. Jenkins and myself. Before delving into the possibility of a meeting, I believe it is crucial to clarify the status of the ongoing legal action. As we have previously discussed in our previous correspondences, the pending legal action threatened by GreenSquareAccord remains unresolved. It is imperative that we definitively address this matter by either withdrawing the threat or formally discontinuing it before proceeding with any further discussions. While I appreciate GreenSquareAccord's willingness to engage in a dialogue aimed at improving the landlord-tenant relationship, my foremost concern remains the resolution of the outstanding legal issues. Once GreenSquareAccord formally withdraws the threat of legal action or provides an official statement confirming its cessation, I will be open to considering discussions aimed at resolving the issues at hand. I would like to reiterate the guidance from the Housing Ombudsman, which clearly states, provide a written apology to the resident from a senior member of staff for the failings identified in this report and offer to meet with the resident if he wishes to do so to provide the parties an opportunity to rebuild the landlord-tenant relationship. In light of this, I kindly request that any further communication regarding this matter be directed to me directly. My spouse has already granted GreenSquareAccord explicit authorization to act on her behalf through an authority to act form which is on file with your client. Additionally, it is important to note that I am not bound by any form of contact management plan. I also request that if GreenSquareAccord continues to insinuate my use or intention to employ offensive, abusive, insulting, aggressive, or intimidating language towards any GreenSquareAccord representative, they provide evidence which has been lacking thus far. Furthermore, I would like to point out that GreenSquareAccord's recent communication not only disregards the content and agenda I outlined in my letter dated 14th of September, but also neglects to provide the names and roles of the individuals from GreenSquareAccord who will participate in any proposed meeting. To avoid any misunderstandings, it is crucial that Ruth Cook attends, given the recurring issues and communication challenges I have encountered with GreenSquareAccord's middle management. Additionally, I emphasize the importance of this meeting being conducted in person so that all parties can be certain of who is in attendance. It is also worth noting that GreenSquareAccord does not possess the authority to mandate any undertaking as to acceptable behavior, as mentioned in their letter. Considering GreenSquareAccord's history of not providing accurate records, meeting minutes, or call recordings, it seems reasonable that any future meetings be documented or recorded to ensure mutual respect and accurate notes are provided to both parties. In conclusion, I am deeply concerned about GreenSquareAccord's letter, as it appears to undermine the ongoing legal actions, dismisses my legitimate request for clarity on the legal status, and fails to adhere to the agenda I proposed, while showing no consideration for my wife, myself, or the complaint process outlined by the Housing Ombudsman. I kindly request that you promptly relay this matter to your client and seek a clear and formal statement confirming the withdrawal of any impending legal action. In light of your out-of-office reply indicating your annual leave, I am willing to extend the previously stipulated deadline until 29th September 2023. I appreciate your attention to this matter and eagerly await your response. Sincerely, Ben Jenkins. All of this was disregarded by GreenSquareAccord, who then chose to move forward with what we now know to be an unnecessary and costly legal action.
Now, look, the day before we were due in court, I was due in court, however, my wife has supported me through all of this, being a concerned and worried tenant, along as with our neighbours and the wider community. Before the day in court, I received hand-delivered, same as when you get served. Someone knocks at your door and, Mr. Jenkins, here you go. I was hand-delivered a bill for the costs, which at this point were just over £9,000. So I was subject to these costs, £9,000. And if that's not further use of the fear and the threat and the intimidation in order to get me to back down, I don't know what is. So obviously these things have an effect and worry on you. Well, okay, if I've got to find 10 grand, I'll find 10 grand, right? You know, I'll pay off £5 a month, you know, worst case scenario. So we go to court, and I had paid for an hour's legal advice, and the legal advice had sort of said, well, look, you might want to offer some undertakings. Now, I had been approaching mediation, and we'll come back to this, but mediation to GreenSquareAccord in order to hand over the site to them in a way that wouldn't involve court action. Would have saved us all money, but that was frowned upon. It was ignored. We'll come on to that at the end. So I turned up at court, but with the court I had provided my response to their witness statements, which you can find on the website, the GreenSquareAccord residence website there. I responded to their witness statements, and I'd written a letter to the presiding judge, which offered some undertakings. I'm not going to take down the website, but there are a few things I thought, well, I'm more focused on the housing sector now. I don't need to do this. I've gotten to the point where we are. The housing ombudsman settled, so kind of ready to move on from it.
Letter to the presiding judge. To the presiding judge, I am currently facing a case initiated against me by the claimant, GreenSquareAccord, which is scheduled for consideration on November 9th, 2023, under claim number K70X068. This legal action stems from my establishment of the website www.greensquareaccordresidence.co.uk and associated social media accounts. Since 2019, I have been actively supporting residents of this housing provider by addressing issues, guiding residents through the complaint process, and, when necessary, escalating matters to the housing ombudsman. To effectively raise these issues, I have, on numerous occasions, utilised social media platforms and sought assistance from third parties, such as members of Parliament, councillors and regulatory bodies like the Information Commissioner's Office. In an attempt to curtail the impact of these actions, the claimant has initiated the present proceedings, seeking to prohibit the activities I currently employ. The claimant alleges that my actions are interfering with their ability to manage their customers and characterises my behaviour as threatening and abusive. For the factual background, please refer to my response to the claimant's witness statements enclosed. It is disheartening that the claimant has chosen to disregard my repeated pleas for mediation and my offer to transfer control of this website and its associated social media accounts, as evidenced by the enclosed records. In light of the concerns I've raised, which encompass various health and safety issues and risks to life, coupled with the claimant's repeated failures in meeting their service level agreement, many of which have been confirmed through the claimant's own complaint process and by the housing ombudsman. My actions have not only provided support and assistance to my own family, but have also extended to benefit over 43 residents within my block and other individuals residing under this provider's care across multiple counties. It is evident that had the claimant heeded these concerns, when initially brought to their attention, there would have been no need for me to create the website, its affiliated social media accounts, and the related content. I have provided to the court multiple copies of email exchanges which highlight some of the issues, as well as letters of support from residents I have helped. The claimant, having ignored repeated requests, has made it clear that they intend to use funds that could be better spent on fixing issues and have employed the full weight of their legal partners. It is clear that this is to bully and silence not just myself, but all the residents who have sought my support after being failed by this housing provider. Undertakings. Given my limited legal expertise and financial resources, which the claimant is well aware of, I hereby propose the following undertakings in relation to the following. 1.1. The website, www.greensquareaccordresidence.co.uk. 1.2. The Twitter account, https://twitter.com, residence GSA, and 1.3. The Facebook ID 107304705905, page https://jardim, facebook.com, profile php, 1.4. The email address, contact GreenSquareAccord Residence, Code UK. 1.5. The website page, www.ruthcook.co.uk. And 1.6. Any other website, social media accounts or email addresses which may mislead members of the public or our clients' current or potential suppliers, contractors or agents to believe you are a tenant of, or are acting with the authorization of, or are connected to, our client. I believe it would not be appropriate to take down the website, associated social media accounts, email or address, as the claimant has failed to provide any evidence to establish that this site misleads people into believing it is associated with the claimant. It is evident that this site and its associated social media accounts were created to offer support to other residents who have experienced failures by the claimant. 2. Creating any future website or social media presence which may mislead members of the public the claimant's tenants, or the claimant's current or potential suppliers, contractors or agents to believe the defendant is a tenant of, or is acting with the authorization of, or is connected to the claimant. Since I have not created any site that misleads the public, tenants or the claimant's current or potential suppliers, nor do I have any intention to do so, this request is also unfounded and unnecessary as part of these undertakings. 3. Reproducing any of the claimant's logos on any website, social media platform, digital or hard copy correspondence, or on any other digital or hard copy documentation. The use of the claimant's logo is conducted within the scope of the copyright concept of fair use, which permits the use of copyrighted work for purposes such as criticism, review, or quotation. 4. Contacting the claimant or any of the claimant's employees directly. For the avoidance of doubt, such behaviour includes but is not limited to in person, using the said employee's work or personal email address, using or messaging them on their work or personal mobile telephones, using social media direct messaging and or tagging the said employee on personal social media accounts, or using the claimant's social media accounts in such ways. I hereby agree not to contact any of the claimant's employees as specified above. All communications will now be channeled through my appointed lawyer, Dispensation Lawyers. Any issues related to our home will be submitted through my wife, who is the legal tenant of the claimant. 5. Recording members of the claimant's employees, contractors or agents, unless the defendant has the person's prior written consent. I record all calls due to my ADHD, which helps me keep track of agreements, timeframes, and transcribe calls into minutes for future reference. Since I've agreed not to contact any members of the claimant's employees, the recording of calls is no longer relevant in that context. However, if any of the claimant's employees contact me directly, please be aware that these calls will be recorded, and their direct contact implies consent to the recording of said calls. 6. Refraining from using any hashtags which specifically name any of the claimant's employees, including the claimant's directors, and specifically including, but not limited to, Ruth Cook, contractors and or agents. Agreed. 7. Using threatening, abusive or aggressive language towards any of the claimant's employees, agents or contractors. I have consistently refrained from employing any threatening, abusive or aggressive language when interacting with the claimant's employees, agents or contractors. To date, the claimant has not presented any substantiated evidence of such behaviour on my part. This conduct is inconsistent with my established demeanour, and it would be unjust for the claimant to insinuate that I may suddenly engage in such behaviour. 8. Engaging in any conduct that causes or is likely to cause a nuisance or annoyance to any of the claimant's employees, agents or contractors. Determining what might constitute a nuisance or annoyance to any of the claimant's employees, agents or contractors is inherently subjective and uncertain. Given this ambiguity, I am unable to provide my agreement to this specific undertaking, as it may inadvertently lead to a breach of the undertaking, due to a lack of clarity regarding its scope and implications. In conclusion, I hope that my offered undertakings demonstrate my commitment to resolving this matter while ensuring the well-being of all parties involved. My actions have consistently aimed at addressing critical issues affecting residents and holding GreenSquareAccord accountable for its responsibilities as a housing provider. I look forward to a constructive resolution to this case, which priorities the concerns raised by the residents and ensures their safety and comfort in their homes. I believe that a collaborative approach is the most effective way to achieve this goal. I kindly request that the court consider these undertakings in a fair and impartial manner, recognizing my intention to work towards an equitable resolution that upholds the principles of justice and resident welfare. Yours sincerely, Ben Jenkins.
When we got to court, their barrister came over. This is no hardship on her. She's at the start of her career, and it's sort of my understanding that when you start out, you get given the cases that you don't really have a chance to win. So you learn how to argue, you learn how to debate, and you learn how to strengthen your procedures. So as your career progresses, you become better. It was clear to me that she was a little bit lost, and she came over. Hi, Mr. Jenkins. We've read your letter to the judge, and we'd like to agree to those undertakings. And I said, no. I said, you rang this bell. We're going in front of the judge. To which all the colour drained from her face. And I went back to my wife and said, if I was playing poker with my mate John, I'd bet the mortgage, bet the house, bet the van, because they've got nothing. And sure enough, when we went in front of the judge berated them for about 10-15 minutes. It was really embarrassing for them. This was called a backdoor prosecution. The fact that they were arguing copyright in the county court rather than in the Crown Court, and that actually what I was using was fair use, it probably wouldn't go. Had we had the legal expertise, it would have been clear that she wasn't going to rule on it in their favour in any way. She did mention an adjournment. Now, me and my wife were like, oh, God, we just want this to stop. You know, we don't want to go through all this worry. And how long's an adjournment? And then, again, if we lose, there's more costs. But in hindsight, looking back, the judge was pretty much hinting that, you know, that there wouldn't be. She wasn't going to find in their favour. So, anyway, we came out of court. And I stripped down the undertakings that I'd offered because I thought, well, not offering half of them now. Again, we can show those. Let's have a look at those now, shall we? Let's have a look at the undertakings I actually offered.
Undertakings offered in court. On the 9th day of November 2203, Mr. Ben Jenkins appeared in person and gave an undertaking to the court promising 1. By 4 p.m. on 11th November 2023, the defendant, Mr. Ben Jenkins, will a. Disable link to the following web pages such that it cannot be accessed by any member of the public. www.ruthcook.co.uk. b. To clearly display in bold font a statement in the following wording. This website is not affiliated with GreenSquareAccord Limited, which has its own formal complaints process. We will signpost you to the relevant parties and provide you a written statement that you can provide as the basis of a formal complaint. On the website pages listed below, www.GreenSquareAccord.report issue and www.GreenSquareAccord on Ruth Cook. Letters to our CEO, the defendant, Mr. Ben Jenkins, will not, whether by himself or by instructing, encouraging or permitting any person to contact the claimant or any of the claimant's employees, agents and or contractors directly. For the avoidance of doubt, contact includes but is not limited to using work or personal email address of the claimant or claimant's employees, contractors or agents, using telephone or messaging the claimant or the claimant's employees, contractors or agents on their work or personal mobile telephones, and using social media to contact the claimant or claimant's employees, contractors or agents. Using social media includes but is not limited to direct messaging. For the avoidance of doubt, social media includes LinkedIn. B. Tag the claimant's employees, contractors, and or agents on social media, including personal social media. For the avoidance of doubt, social media includes LinkedIn. C. Use any hashtags, whether on social media or otherwise online, which specifically name any of the claimant's employees, contractors, and or agents. This includes but is not limited to Ruth Cook and any other director of the claimant. D. Refer to any employee, agent or contractor of the claimant by name within any publication online, save for those individuals named GreenSquareAccord, About Us, Our Team, or have the word director contained within their job title at the time of publication on the webpage. Publications online includes but is not limited to any web, social media or blog posts, and be bound by the promises until 23:59 hours on 12th May 2025.
Okay, so the undertakings were agreed. I didn't have any costs. Off we went I had lunch and thought, right, that's behind us. GreenSquareAccord, in their normal way, let's spin the truth as far as we can to come out as saviours of the sector, responded with this.
Successful court outcome protects GSA customers 10/11/2023. A successful court outcome will help to make sure customers can contact us and get their inquiries dealt with more effectively. On Thursday, 9th November, we secured a legally binding undertaking from Ben Jenkins, who owns and manages a website called GSA Residence. Mr. Jenkins' actions have significantly affected our customers, who have been encouraged to report issues with their service or home to him through his website rather than directly to us, meaning their concerns can't be dealt with effectively. We have spoken with some customers who have contacted Mr. Jenkins through the GSA Residence website, thinking that they were contacting GSA. resulting in unnecessary delays in US dealing with the issues they have raised, or in some cases complaints not being passed on to us at all. Over the last few years, Mr. Jenkins has contacted GSA hundreds of times through various channels, including email, phone and text. He has also contacted colleagues using their personal mobile numbers to send unsolicited messages, texts and videos. This has had a significant and detrimental impact on these colleagues and their ability to provide services to our customers. His actions have used up many hours of GSA time that could and should have been spent dealing directly with customer issues. In the legal undertaking, Mr. Jenkins agreed he can't contact GSA in any way. This includes any GSA employee or our agents or contractors directly. This includes through work or personal email addresses, by telephone or messaging, or via social media. He will remove certain website pages and make it clear on others that he can no longer contact us on behalf of our customers. This undertaking is legally binding, and any breach of it will be dealt with as contempt of court. We would like to make it clear to customers that the quickest way to get an issue with your service or home resolved is to contact us using the details provided on our Contact Us page. If we have not been able to deal with your inquiry in a satisfactory way, full details of how to make a complaint, including details of how to contact the Housing Ombudsman service, are available on our complaints page. The GSA residence website is not a means to contact us, and Mr. Jenkins will no longer be able to contact us on your behalf. If you have previously raised issues on the GSA residence website, it is likely that they have not been passed on to us, and we would urge you to raise them with us directly.
And then, of course, GSA, GreenSquareAccord, being who they are, being ruled by Ruth Cook, were not happy with the outcome of this court case. So I don't think my feet had touched the floor, and I was already being served again, this time for breaching undertakings. Now, what they claimed this time was that I hadn't removed historic web pages, which there is nothing in the undertakings that said I would, but by referencing historic pages, I was still tagging people. There seemed to be confusion over tagging people on social media. So if I tag someone on my website isn't a social media website. It is a website controlled by me. The definition of a social media website is clearly mine isn't. Social media, my website. I'm not tagging people on social media. I'm tagging them on my website. And we agreed that they could be tagged if they were Ruth Cook on their senior leadership team or had director in their title. And it wasn't something that they were happy to agree to, but they did agree to it, and it's in the undertakings. So they said you breached that. And off we went again. We went through the whole process again. Now, this was supposed to go... We went in November of that year, I think. God, it escapes me now. December. Went in December. Again, I thought it was going to be done and dealt with there, but it wasn't. Right, we're going to postpone. We're going to get this thing in order. At which point the judge said to me, Mr. Jenkins, because this could end up in a custodial sentence, you are now entitled to legal aid. Okay, so I can get legal aid. So all over Christmas, we have this sort of threat hanging over our head. And in February, the court case was due again. Now, the thing that sticks with me and my wife is we just wanted to get wrapped up before Christmas, thought it'd be done, thought it'd be dismissed because there's nothing there. And the judge even said, I don't think he's breached the undertakings. I can't see where he's breached them because there's nothing about the removal of historic web pages. At which point this sort of young barrister said, no, but there ought to have been. And the judge rightfully said, we don't deal with ought tos in this court. We deal with fact. The fact is, there's nothing in there about me removing historic web pages. So off we went. We got it. Had to come back, so we had that to worry about. And I went and got some sort of legal representation, and we lined up a barrister. And then the barrister said, this is a complicated one. Probably can't get it done in an hour, so we'll need half a day. So then it got postponed to August, which is the one that we've just been through. Now, again, it was quite clear from our barrister talking to their barrister that they were a little bit worried that their case was a bit thin. The reason their case was thin, and we didn't even get in court, we didn't really talk about the undertakings. What we were talking about was their failure to, as the judge said, dot all the I's and cross all the T's. Before imposing potentially a prison sentence on me, it is imperative that the claimant has all the paperwork done properly. And they didn't. They hadn't submitted things properly. I don't really know. Now, it's clear when you're in court and two barristers are talking to a judge, they use words that I understand, but they use them in a different context. It would a bit like me saying, oh, the dinosaur's in my car again and I've washed my windows with pasta. They're all words. They just don't make sense in the context that I've used them. And that was his legal speak. So I'm not entirely sure until we get all the paperwork through what it is GreenSquareAccord have failed to do. However, it was dismissed. Not only was it dismissed, but the costs were passed back on to GreenSquareAccord. Legal aid don't have to foot the bill. Why should they? GreenSquareAccord's little circus they're running. Why should they?
So where do we stand now?
So here we are, still in limbo, still the threat of legal action. Expect a knock at the door any day now. You know, there'll be a response to it. We'll go through it all again. I face imprisonment. GreenSquareAccord still trying to keep a tarnished reputation together, still trying to keep things out of the public domain, which is all this is about. And yet it will continue and it will go on. There is no end in sight. And I'll be honest with you, if I need to go to prison for it, then I'll go to prison for it, because I'm at the point where when they first initiated the court case, my website got a bump in traffic. No denying it, almost doubled overnight. Okay, maybe this is what we need. Maybe I need to be a martyr. Maybe I need to fall on the sword so we can really get these issues out in the open. Maybe people within the housing sector world will start to look on this and go, hang on a minute. After all, your silence speaks volumes about who you are. Is this just the GSA way, or is it the Ruth Cook way? Does she just bring shame to her own housing association, or is she bringing shame to the whole sector? I don't know. I honestly don't know. Time will tell, I suspect. I will, and I'm going to do it publicly now, offer, once again, mediation. If someone from GreenSquareAccord, and I think it needs to be Ruth Cook, wants to sit down with me, and we're not going to sit down, have a Zoom, and you dish out rules and regulations and how we will. I have never been discourteous to any of your staff. I have always been polite. We're going to sit down, and if you want to hammer out some sort of statement that we can both put out combined, some way that we can move the GreenSquareAccord resident website over to your control, let's do that. Let's work together, as I've suggested all along. You work with one of your most vocal, disgruntled customers, build that bridge, fix these issues. What have we got to lose? Legal action ain't doing you no good, reputation-wise. Ain't doing me no good, stress and worry. It's not doing any of us any good cost-wise. How many times are you going to keep trying to do this? I know that you like having the, we're using legal action. Oh, is legal action pending? I know that suits you well. I know that works for you. You know, stop Ben from speaking. If he speaks out and he says anything, tell people that there's legal action pending. I know that fits your narrative. It's not going to keep lasting, though, is it? Because the narrative now is that you can't do this. You can't shut down a website. Perhaps you should be subject to negative feedback. Perhaps you could learn from it. It's not just me, is it? It's the Housing Ombudsman. It's the Department of Levelling Up. It's Wiltshire Council. It's online reviews. It's Trustpilot. It's Google. You know, I'm the only one that you can come at, and you come at me. Are you going after other residents? Did you go after that Facebook group? Who knows? Perhaps this really is the GSA way. Bully, threaten, intimidate. Keep running until the person's exhausted and just gives up, or goes, I'm not going to court. I'm not going to prison. I don't want to, and gives up. Well, you've met the wall here. I'm not going to give up. I'm going to keep fighting for the rights of your residents. I'm going to keep raising their issues. I'm going to keep sharing your shortfallings. And if needs be, I'm going to go to prison for it. This is where your narrative stops. It stops here with me. If you want to talk, if you want to go through mediation, let's sit down like adults, let's talk. And let's put out a statement together where we can start to rebuild the bridge and start to work together to provide a service that you should be providing already. You can start to display behaviours that don't cause you shame, that don't bring shame upon your CEO, your senior leadership team. And I'm starting to think that less and less of them actually agree with the way that you're going. The people that I've met almost seem embarrassed by it. And so they should be. And is it the rest of the sector? They sit in silence when they should be ashamed. Should they not be calling you out? Well, maybe it will take me having a spell in prison. Heck, I could use the gym. I've got some time to do some reading. I'll probably sleep better than I do here. So who knows? Maybe prison will do me good. I'm not so sure I will thrive well, but it's a course that I'm chosen to take them. This has been the GSA Way. This is the end of the latest court case. Expect another one soon. Or mediation. Either way, we'll keep you updated. Thanks very much for your support and your kind words. It really helps. Now you can help me again by sharing, by liking, by supporting this video. And if you know of anyone else who's going through action from their housing provider, please let me know. I might be able to give them a few pointers. Anyway, signing off. Thank you very much indeed. This is the GSA Way.
Ruth cooked at the helm, but the culture ain't right. Complaints every day, customer ignored, never get their say. Never get